Hello, everyone, and welcome to the third talk in the CIPIL evening series of talks this term. I'm very pleased today to welcome Dr. Emily Hudson, who is a reader in law at the Dickson Poon School of Law at KCL, King's College London. Emily teaches and writes on intellectual property. She recently published a book with CUP in 2020, in fact, called Book Drafting Copyright Exceptions. Sorry, the book is called Drafting Copyright Exceptions from the Law in Books to the Law in Action. She's also published a number of chapters. Perhaps one of the most interesting is one that she has done over the COVID pandemic, which is copyright educational guidance for universities during COVID. I'm not sure I got the title exactly right, but basically it's guidance for courses which show whole films, often film courses at universities, and gives them guidance about what they should do during the COVID pandemic. But today, although she's published very widely on copyright, Emily has now begun a project on trademarks, and today her talk will be about trademarks. Just to say, if any of you who are attending have questions, please do put them into the Q&A, or indeed, if you have a comment, put it into chat, and we'll go to those when Emily has finished her talk. But anyway, so let me introduce Emily Hudson, and she is going to talk tonight on the concept of reliance in trademark law. Emily.
Thank you very much. So you should at this stage, Jennifer, be able to see my slides. If I can just get a thumbs up from you, thank you, that they appear. So thank you to CIPIL for the invitation to speak tonight. This is, for me, an early work in progress seminar. So this is a relatively new project that I'm undertaking in association with my colleague, Professor Robert Burrell at the University of Oxford. And the inspiration for this project was the decision of the Court of Appeal in Nestlé and Cadbury. And this related to the registration of what has been termed the naked shape of KitKat. So that is the shape on the top right of screen, which is the 4-finger bar, but without any words written on the fingers. And it was held that this shape could not be registered because Nestlé had failed to establish that it had acquired distinctiveness. And one of the things that comes through in the decision of the Court of Appeal, but also in the decision of Justice Arnold in the High Court, is this emphasis on reliance in assessing acquired distinctiveness. So do consumers rely on the shape alone as a badge of origin? And reading this case generated a number of questions to us in relation to the role of distinctiveness in the trademark law, in relation just to some of the neuroscience that sits behind this proposition that reliance can be used to help or indeed forms a central limb of the test of acquired distinctiveness, at least for shapes. So whilst the project sort of started on a sort of somewhat more narrow set of questions in relation to the KitKat decision in particular, I think it raises some bigger themes in relation to distinctiveness in the trademark system, and indeed the degree to which trademark law reflects what we know in the neuroscience about how people interact with trademarks and brands. So what I'm going to do today is talk a bit about the case law and reliance as a concept in the case law, then introduce some of the critical questions that we plan to cover in the project, and then conclude just with a few remarks about the sort of methodology for the project. So the sort of feedback that we'd find particularly useful might relate to ideas for questions that we might consider, suggestions for the methodology and so forth. As I said, it's sort of an early work in progress seminar for us, but hopefully will still be something that you find interesting, even though we're not yet at the end of the project. So let's start with some background in relation to the emergence of this Reliance test. And want to start with issues that are said to arise in relation to the distinctiveness of shapes, that is their ability to serve as a badge of origin. And I think two concerns have come through in the in the case law, I should say. So one is that consumers don't perceive shapes as indicating trade origin. So some of you may recall the statement of Justice Jacob in Bongrain's applications, which related to an attempt to register the shape of cheese, so a floral shape comprising 6 lobes. And Justice Jacob said that an average consumer would be astonished to be told that one of the shapes was a trademark. Consumers do not expect to eat trademarks or part of them. Furthermore, Justice Jacob has also discussed what he's termed the sleight of hand in relation to securing registration over shapes, because they can be what's known as weak or limping marks. So in Unilever, in relation to the shape of Viennetta, he described the sleight of hand as follows, that you have a proprietor who produces a well-known product under a well-known mark, and over time the product appearance will likewise start to become well-known, such that the proprietor then seeks to secure trademark protection for that appearance as well, despite the fact that the product's never been sold solely by reference to its appearance or shape. It's always been sold by reference to a highly distinctive word or logo mark. And his concern was that at this point, if the registration is accepted, that other traders won't be able to use a similar shape or will be exposed to a possible trademark infringement action, despite the fact that they sold their product by reference to their own distinctive word and logo marks, and therefore may not have confused any consumers. And indeed, that case, Unilever's trademark applications, also is one of the cases in which we see reference to Reliance. And I just thought I'd pause on some of the facts of that case and other things that Justice Jacob said. I know that for some of you this will be revision, including you, Jennifer, but there might be people for whom this is new information. And I think it's well worth going through some of what Justice Jacob says, because what I'm going to suggest is that there are certain policy concerns he raises, which I think are actually the true concern as to why we don't register, or why we're reluctant to register shapes, and other claims he makes, which I think more empirical claims that I think are problematic. So this case involved an attempt to register 2 trademarks for ice cream dessert products. And you can see those 2 marks on the slide. They pertain to the shape of the Viennetta dessert. There was both a dark and a white version of the mark, these apparently corresponding to 2 different types of Viennetta dessert on the market. Nestlé opposed the registration of this mark for various reasons, including that the shapes were not distinctive. Justice Jacob held that the marks, or Justice Jacob held that the marks should not be registered. And in relation to the concern about distinctiveness, he said a number of things. First of all, he was clearly concerned that trademark registries should not register shape marks simply because those shapes were unusual or attractive without evidence of use. And he discussed another case, the Yakult bottle case, decided by Justice Laddie, where Justice Laddie also said it's not enough that the shape is eye-catching in terms of being something that consumers might recognize. It must be distinctive as a badge of origin in order to be registered. And that for inherent distinctiveness by nature, the mark must perform this function even before the public is educated that it is to be used for that purpose. And he said, Justice Laddie, this is said that the shape of a container is different. Just because consumers will recognize the shape a second time around doesn't mean that they would ascribe that shape trademark significance. So first set of concerns of Justice Jacob, that registries shouldn't simply be registering shape marks because they're somehow unusual or different. Secondly, Justice Jacob noted the commercial success of the Viennetta product and that the shape has achieved a significant degree of public recognition, but he said that mere recognition is not enough, and that what had not been shown and what needed to be shown was that consumers relied on the mark, relied on the shape as a badge of origin. He makes a number of suggestions in relation to this aspect, including that word marks and logos are different because the public expect them to be trademarks, in contrast with shapes. He said too that in this particular case, Unilever had not advertised the Viennetta shape as a badge of origin. It was really advertised as a vehicle for a delicious ice cream dessert to be transferred into your mouth. Furthermore, and I think this is significant, I'm going to come back to it. He said that when people buy the product, they read the label on the box, which says Viennetta. They might look to other information about which flavor of Viennetta they want, such that they don't use the shape of the Viennetta or a picture of that shape as an indication of origin. But we also see other concerns in the judgment. One of these relates to the use of survey evidence, that surveys are often undertaken poorly, they use leading questions, they have little probative value. And we see actually in later case law, for instance, Marks and Spencer, a concern about the use of survey evidence in trademark cases. Secondly, to the extent that there was a survey in this case, which included showing participants pictures of 4 different shapes of Gatto-style ice cream products, one of which was Viennetta and 3 of which were the closest things on the market to Viennetta. A number of people who completed that survey identified incorrectly other shapes as being a Viennetta dessert. And Justice Jacob emphasized that this was significant. There will always be background confusion. And in trademark infringement actions, we need to bear in mind that one limit of infringement relates to use of a similar sign where there's a likelihood of confusion. So that this could be quite significant in terms of infringement actions being able to be brought successfully against the producers of similarly shaped products. Now, Unilever promised not to sue the people who produced, the entities that produced these existing products, but Justice Jacob said, well, that's all well and good, but what about the interests of new entrants into the mock gatto ice cream market. Those new entrants may not be comfortable with the prospects of having to take on Unilever. And so really what I think this is articulating is a need to keep free argument. That is, that we're concerned about the needs of other traders. Furthermore, Justice Jacob was concerned that lots of shapes become very publicly recognizable, shapes of cars, furniture, toys, and he was concerned that once shapes had a sufficient degree of recognizability, that proprietors could get trademark registrations over those shapes and in effect get a perpetual monopoly over their design. So another need to keep free argument. So let's then jump forward a number of years to Nestlé and Cadbury. And as I indicated earlier, this case concerned an application to register the naked shape of KitKat. There were issues in relation to both distinctiveness and functionality, and the registrar said that the shape was not inherently distinctive and nor had it acquired a distinctive character. This being despite the fact that there was survey evidence to suggest that at least half of the people who completed the survey, when shown a picture of the naked shape, recognized it as a KitKat. The registrar gave a number of reasons for saying that this didn't show acquired distinctiveness, including that the products sold in an opaque wrapper, so you can't actually see the shape at the point of purchase. And there was no evidence, and nor did the registrar think it was likely that people would open the KitKat and use the shape as some sort of ex post verification that they had brought the correct product. This decision was appealed to Justice Arnold, and I've got a few slides here which are sort of walls of text, but I'm not going to dwell on them for too long. Justice Arnold referred to the Court of Appeal a question about how we approach acquired distinctiveness. Is it sufficient that a class of people recognize and associate the shape with the applicant's goods, or must they also rely on the mark as indicating the origin of goods? This question was reformulated by the Court of Justice instead to refer to perceiving the goods or services as originating from a particular company. And as indicated on the slide, the Court of Justice said that the applicant must prove that the relevant class of persons perceive the goods or services designated exclusively by the mark applied for, as opposed to any other mark which might also be present as originating from a particular company. And when this then returns this case to the UK courts, there is a question of how to deal with the reformulated questions. Justice Arnold thought that the language of perceive was very close to rely. He was critical of the approach in terms of the reformulation of the questions, but he was able to proceed then on the basis that the sort of reliance standard was not made out. And similarly, when the case was then further appealed to the Court of Appeal, Lord Justice Kitchen saw reliance as a behavioural consequence of perception. So in this instance, both Justice Arnold and the Court of Appeal agreed that the shape did not have acquired distinctiveness. As part of the project, we're looking at how the KitKat decision has been received around the world. So one jurisdiction where the reliance test has had particular bite has been in Singapore. And two particular cases on this slide. One is Nestlé and Petra Foods. Also in relation to the KitKat shape. And I think here that the Singapore Court of Appeal really doubled down on the need to show reliance and invalidated the 2 and 4 finger KitKat mark. There was also a case, this was a decision of the office from David Llewellyn in relation to the Ferrero shape as shown on the slide. So the brown cup with the gold ball sitting in it. Ferrero Rocher sought to argue that there was acquired distinctiveness. They put forward various things by way of evidence. So for instance, photographs of displays of Ferrero Rocher balls from a distance where what you see is a pile of brown and gold balls. You don't see the wording. They used survey evidence, which I think was not well done. It was criticized by David Llewellyn for various reasons. And it was held that Ferrero Rocher could not register that mark, and that decision has not been appealed further. So that's a sort of overview of the emergence of reliance, where it's come from and how it's being used. Now I want to include some critical analysis of why we were concerned about reliance. And I think one thing I should say by way of sort of background is I think that for people who are concerned about trademark overreach, for people who are concerned about weak marks being registered, I think the outcome in KitKat was quite attractive as a way to deal with these weak limping marks, to deal with the sleight of hand that Justice Jacob referred to in Vianetta, and indeed that statement was referred to by Lord Justice Kitchen in KitKat. But we have a number of concerns and questions about reliance as a test, and I'm going to take you through them for the remainder of the presentation. First thing we need to note is if we took reliance seriously, it could have huge consequences. So far, I've taken you through case law in relation to reliance as a standard in relation to shapes, but is it just about shapes? Or is it about other marks? And if it's about other types of marks, which ones? Just exotic subject matter? Could it apply to words? I mean, slogans is an example. Are slogan marks all now invalid because people don't rely on a slogan as a badge of origin, in as much as you don't walk into the shop and say, I'll have a break. You would walk in and say you'd like a KitKat. There's also a question too about whether or not reliance is really an empirically grounded test, a policy handbrake, or both. And so one of the things I'm going to get to, well, actually we'll start it now, but then get to it even more so in a moment, is what we might know about consumer psychology and neuroscience about how people might make purchasing decisions. So I'll use a few examples to sort of get this started, and then also refer to some of the studies. So let's say you roll up at the shop and you want to buy a pair of trainers with the swoosh on the side. So first of all, you'll make a decision about which shop you want to go into. For instance, that could be a department store, it could be a Nike concept store, it could be a store that specializes in sports equipment. And once you're inside, you'll then decide which part of the store to browse in. You'll see the trainers on the wall. At that point, there might be also information on tags in relation to the brand of the product, the name of the particular model, its price point. You'll probably want to try the trainers on, and at which point somebody will head out the back to collect an orange box, which will also have the swoosh on it and other details. And so you've got the point being, you've got all this information from where you're located in the store, the swoosh, the brand name, the price point, information about the model, whatever discussion you have with the sales agent. And in this context, where there's lots of different pieces of information, is it accurate to talk about consumers relying on any one element, such as the shape of the goods, in the KitKat case, or the color of the shoebox, or indeed the swoosh, in making their purchasing decision, given all the information that's present? Now, Justice Jacob made a similar point in Viennetta. Recall that he said that when people are buying a Viennetta, they'll see the information on the box, the word mark Viennetta, the flavor, such that they're not relying on the shape of the product or the picture at all. But is that right? So for instance, do we then also need to, though, compare the difference between the familiar and the unfamiliar consumer? So let's say I visit Jennifer's house and I like the brand of ice cream that Jennifer sells, and when I'm next to the shops, I want to buy it. The evidence suggests that the thing that sticks most in the minds of the unfamiliar consumer is not the words, but things like the colors and the shape of the packaging, the picture on the front, maybe even the slogan. So that is, people who are familiar with the product may well rely on the name in order to identify the product they want, but people who are unfamiliar rely on a very different set of elements. And indeed, we shouldn't forget those who may have issues with written English. So those whose literacy is lower, those who have English as a second language, they might also be far more likely to rely on things like colors and shapes rather than word marks, even if they are familiar with the products. Then we've got the different stages of the product. So imagine the time, for instance, when Haagen-Dazs ice cream first came out onto the market. Assuming the word mark was inherently distinctive, it leaves the question of whether consumers could bring that word mark to mind, or whether this took time, and that in the interim, they were relying on the whole product get-up in order to identify the product that they wished to purchase. And it may be that over time they came to remember the name, and that this became perhaps quite a strong and distinctive mark. But the backdrop is a period where people very much relied on product appearance. So I think one of the things to bear in mind is that we have, in relation to Reliance, a whole bunch of assumptions about what consumers take in and are influenced by, often of which may have no basis in any sort of scientific data. It's just sort of judicial heuristics and rules of thumb, and we need to ask whether or not they map onto the science. So let's talk a bit more about some of the science. And some of you might be familiar with this experiment in relation to Coke and Pepsi. So the so-called Pepsi paradox, which is that in blind tastings, a majority of people report they prefer the taste of Pepsi, but when they are asked the same question, knowing which beverage they're drinking, a majority say they prefer the taste of Coke. And this experiment has been used to illustrate the role of subconscious factors in the way in which we perceive and enjoy products. Because when asked, most people will deny that they were influenced by the advertising. So most people do not say, I prefer Coke because I too want to be an impossibly thin person on the beach, or going out to parties and drinking full strength Coke. And yet the evidence suggests that those sorts of brand messages play a really, really strong role in how we consume and think about products. So there are studies, for instance, brain imaging studies involving, which have suggested, I should say, that when we contemplate brands we like, there's an activation of the ventromedial prefrontal cortex, which gives, in the words of Molodinov, gives us a sort of warm, fuzzy feelings when we think of brands that we like. So that Pepsi paradox experiment has been repeated with two sets of subjects, one of whom have an intact functional VMPC and others of whom have had some sort of damage to the VMPC such that it doesn't work. And what those experiments have shown is that the Pepsi paradox does not work for people with a damaged ventromedial prefrontal cortex. That is, when they don't know whether they're drinking Coke or Pepsi, they prefer Pepsi. And when they do know that they're drinking Coke and drinking Pepsi, they still prefer Pepsi. You may have heard of some other studies in relation to the subliminal effects on our purchasing decisions. For instance, the French-German wine study, where the experiment involved a supermarket set up with French wines and German wines, and they were matched for dryness and price. And on some days, there was French music playing in the background of the supermarket, and other days there was German music. And there was a real correlation between what music was playing and the amount of French and German wine sold. So on days when French music was played, 77% of the wine sold was French, and when German music was played, 73% of the wine sold was German. And yet few shoppers acknowledged that their behavior was influenced by the music. And so researchers in relation to brain science and neuroscience, they sort of pull this together, I think, to explain the degree to which our own implicit associations and subconscious factors influence how we experience the world. So in relation to the Pepsi paradox, the reason why people say that Coke tastes better than Pepsi when they know they're drinking Coke is because it does. They actually experience the taste differently. It's not just a set of sensations coming from the taste buds and from the sense of smell and so forth and the mouthfeel, that there's actually also these other inputs from within the brain that influence how the taste is experienced. Johnson and Gurman, for instance, refer to everything we experience being a simulation. We don't experience the world directly, but our own internal description of it. And that this internal description that we create is not just generated by information from our senses, but also from our own associations and expectations. So what some of the material I've just been talking about suggests is that consumers are exposed to lots of different information. The effect of some of this information is subconscious. And indeed, we can add further variables and complexities to this sort of sense of this notion of what people rely upon, or what information, I should say, people process. So the familiar versus the unfamiliar consumer, people with better and worse levels of literacy. These factors all influence how we process and understand different pieces of information. And so we then have, to go back to the case law, this idea of reliance being proposed as important for judging whether or not there's acquired distinctiveness. And so we have questions about how reliance maps onto this framework. When I say framework, I mean the sort of cognitive science and so forth, as an empirical matter. And indeed, if we do think that reliance exists as a matter of cognitive science, what sort of evidence would trademark applicants or proprietors use to establish reliance? As I mentioned, I think judges use a lot of rules of thumb about how consumers engage with goods. So people spend more time looking at expensive goods than cheap goods. Experts are less likely to be confused than non-experts, all manner of heuristics. But are those actually based in any sort of empirical or scientific study? And I think too, then there's just some further questions as well. How do you ever show reliance for other aspects if there's a word mark on the product? And it may be that that's the point, that in actual fact, we want to very much limit the ability for proprietors to get trademarks over these other aspects of product appearance. Now, there's also a question too on this slide about, does reliance make sense in a registered trademark system? And this question reflects the idea that if we just had a passing off analysis, we'd do a whole of product comparison where we compare all of how a product appears, its trade dress with, for instance, the defendant's product. But in a registered system, we have to delineate things. The whole way a registered system works is to have registrations on individual aspects of the product, its name, the logo, the shape, the color, and so forth. So we end up with, instead of assessing appearance as a whole, the whole point of a registered system is that you start actually getting property protection for individual elements. The thing is, though, that if we're talking about reliance, consumers don't interact with a trademark register, they interact with a product on the market. So there is a question, and in fact, this goes more generally to the question of how confusion works in a registered trademark system, that on the one hand, we talk about consumer confusion, but on the other hand, the property right is very much determined by what you put on the register, not the product or service as it exists on the marketplace. So to bring this all together, and I've just got a couple more slides, so I'll be finished shortly. One of the questions for this project is this really about the need to keep free? And this takes us back to what was said by Justice Jacob and Vianetta, that many of his concerns were actually about the position of other traders. The entrant who doesn't want to get into a fight with Unilever, ensuring that traders can't get a perpetual monopoly over their designs, that confusing similarity might make the trademark monopoly too broad. And so this raises a question of whether, in fact, reliance might provide what some people might say is the right outcome in terms of limiting the circumstances in which shape marks can be registered and perhaps other marks, but whether or not it doesn't truly discuss the reasons. And it may be that we've thought about this in terms of shape marks because there's much more of an intuitive sense that shape marks are very readily depletable from the commons, compared with word marks, for instance, where there's often a sense that there's always another word you can invent or use. So word marks don't deplete in the same way. Bearing in mind, though, some recent scholarship to suggest that actually that may be overstated because, for instance, and I think this was a point made by Beebe and Froma, the good word marks get taken first. I think too that in thinking about the need to keep free and whether this is much more of a policy handbrake, I think too, just to perhaps step back to and think about the purpose of the trademark system and the degree to which it's much more about brand space and protecting that brand space rather than truly protecting confusion. That is, if we look at the infringement grounds, double identity infringement arises where there's no danger of confusion, and confusion is not an explicit requirement for that head of liability. We use confusing similarity in a way which doesn't truly consider confusion, because of the way in which the analysis is very much more about comparing the similarities between the marks and the goods and services rather than asking whether anybody was truly confused. And section 10.3 doesn't even rely on confusion. So one thing to think about is we have a system which actually isn't at times truly about confusion, and then this test of reliance which seems very consumer focused. And one of the things that I think we want to think about in this project is whether there are some bigger lessons about how the trademark system should be set up. So a strong but narrow registered right, which is very much about the need to keep free, perhaps sort of much more about traditional marks like words and logos, and then everything else dealt with through passing off with a true consumer focused test. So in terms of what's going to happen next, there's a couple of things we want to do in this project. One is a systematic review of the case law in relation to reliance. We've begun this aspect of the project, looking at a number of different jurisdictions to sort of try to get a sense of how the concept of reliance is being used, but also then approaches to acquire distinctiveness, how shaped marks are treated, and so forth. We also, though, want to engage with the literature in relation to neuroscience, consumer psychology, and so forth. And indeed, one of the things we are thinking about, although this might require some partnership with academic psychologists or behavioral economists, relates to whether or not we might do some empirical work to really sort of push forward aspects of this project. So that's what's going to happen in the future. But that's all for me for now, Jennifer. If anyone has any questions or you have any questions, feedback and suggestions, very much love to hear them, but thank you again for the invitation to present tonight.